Everybody, this is Bob Probst with the Probst Law Firm in Winston-Salem, North Carolina. Today is Wednesday, June 17th, 2020, and this is another segment of the live Facebook talks on Wednesdays at 4 o'clock. Today I'm going to be discussing with you the division of marital assets and marital debts in North Carolina when someone gets a divorce. So the first thing you need to know in that area is what is the term for dividing marital assets and marital debts. Well, in North Carolina, we call that term equitable distribution. It is the equitable distribution of the marital estate. And the marital estate consists of the assets and the debts of the marriage. And then the equitable distribution part means how will the court divide it in an equitable manner to each party. So the first thing you might want to know then, after you understand what the term equitable distribution means, is what is a marital asset? How is a marital asset defined in North Carolina? Well, it's defined actually pretty simply. A marital asset is defined as any asset purchased during the marriage for the benefit of the marriage. And it doesn't matter whose name the asset is titled in, if it's a type of asset that gets titled. If it was purchased during the marriage, then it's going to be a marital asset, generally speaking. And during the marriage means the day of the marriage up to the date of separation, whenever that was. So what types of things are marital assets generally? You have a car can be a marital asset. A house can be a marital asset. A bank account can be a marital asset. A retirement account can be a marital asset. Furniture, pretty much anything you accumulate during your marriage. And it doesn't matter whose name that property is titled in. For example, if the husband has a car titled in his name alone, but it was purchased during the marriage, it is a marital asset to be divided upon divorce, the value of it. If a wife has a retirement plan that she contributed to during the marriage, and that retirement plan's in her name alone, the contributions made during the marriage is a marital asset to be divided upon the divorce between the parties. Bank account in husband or wife's name alone is a marital asset. The funds put in there during the marriage is a marital asset to be divided at the end of during the divorce. So the next thing you might want to know then is, okay, that's what a marital asset is. How is a marital debt defined? In North Carolina, marital debt is defined as any debt incurred during the marriage for the benefit of the marriage. Again, it doesn't matter whose name the debt is in. It will be a marital debt to be distributed at the time of divorce if it was incurred after the date of marriage but before the date of separation. So what kind of debts do we typically see that have to be divided in a divorce? They can be a mortgage payment on your house is a marital debt. A car payment on your car is a marital debt. A credit card in your name is a marital debt. So for example, let's say a wife has a credit card in her name. That is a marital debt that the court can divide and give the husband some of that debt at the divorce, even if the credit card is not in the husband's name. Or let's say a husband has a car with a debt in his name. That debt can also be divided and partially given some of it partially to the wife at the time of distribution, even though the debt is titled in just the husband's name. So again, the key for those two things is if you have a marital asset that was purchased during the marriage, no matter whose name it's in, and if you have a marital debt that was incurred during the marriage, no matter whose name it's in, that's going to be part of the marital estate that's going to be divided by the court upon the divorce. So that is what your equitable distribution in your marital estate is about. Now, the next question you might have is, okay, now that we know what our marital assets are, and now that we know what our marital debts are, how are they going to be divided by the court? Well, in North Carolina, the marital estate is presumed to be divided on a 50-50 basis. So that means it's presumed that the court will start with 50% of the assets go to the husband, 50% of the assets go to the wife. 50% of the debts go to the husband, 50% of the debts go to the wife. Now, how those debts get divided and how those assets divided will be up to the court, but the court's going to try to balance it so each party gets 50% of assets and 50% of the debts. Now, there are some statutory reasons for dividing it something other than 50-50, like a 55-45 split or a 60-40 split. And there's a lot of statutory options for the court to use that you, if you're representing yourself or your lawyer, will point out to the court when they ask for a greater than 50% distribution for you. But the court does have to start from the very beginning with the presumption that they're going to give 50% of the assets to husband, 50% of the assets to wife, 50% of the debt to husband, 50% of the debt to wife. And they're going to make you file affidavits that list all of your assets and all of your debts, so the court will have something to look at in trying to divide those things up. Now, there's two ways for that marital estate to be divided equitably through equitable distribution. Those two ways consist of, one, by a property settlement agreement, and two, by the court after you go through a trial. So let's talk about the property settlement agreement first. In North Carolina, two competent adults can get together and decide how they're going to divide their marital estate. Who's going to take what asset, who's going to take what debt. And then if they memorialize that or they write that down into a property settlement agreement that's in the right form for the court, both parties will be held to that agreement. So when you're sitting down with your spouse and you're talking about a divorce and you're starting to divide the assets and the debts, before you sign anything, make sure that's what you want to do. Make sure that division is in your best interest. You may want to take, if your spouse drafts a property settlement agreement, you may want to take that to an attorney to have them review it with you so that they can give you their advice as to whether the distribution in that agreement is a good deal for you or a bad deal for you. Because once you sign it, if it's done properly, you're going to be stuck with whatever you agree to in that property settlement agreement. Now, let's say the parties separated, but the two of you cannot agree on what to do with the assets or the debts. Then you can ask the court for what's called an equitable distribution hearing. And there a judge, not a jury, just a judge will hear the case. And the judge will have you list all of your assets and the value of those assets. The judge will have you list all of your debts and the value of those debts. And the judge will hear different evidence and arguments of counsel, but in the end, the judge will sit down and say, husband gets asset ABC, wife gets asset DEF, husband gets debt ABC, wife gets debt DEF, and they'll divide it all for you. May not be how you wanted it divided, may not be how you wished it would have been divided, but if you can't do it yourself and you go to court, then the court will divide it. And once the court divides it, you're stuck with it, unless you want to file an appeal, of course, but for most people, they're just stuck with that division. So you want to think about it as you separate from your spouse and as you look at your marital assets and your marital debts, you want to see if there's a way the two of you can resolve it together, taking into consideration your family structure, your ability to earn income, your spouse's ability to earn income. For example, it might be important for one spouse who has custody of the children to get the house that the children were raised in so they could stay in the house. But you're probably going to have to compensate for that by taking on some debt or giving your spouse other assets that will equal the value of the house. So that is basically how equitable distribution how marital assets get distributed equitably in North Carolina, right? First, you have to determine what the marital assets are. And remember, the definition of a marital asset is any asset purchased during the marriage for the benefit of the marriage, even if it's in one party's individual name. Then you have to determine what your marital debts are, which are generally defined as debts incurred during the marriage for the benefit of the marriage. even if that debt is incurred in the name of one spouse instead of both spouses. Then you have to determine the value of those assets and the value of those debts, and then you're going to divide them on a basically 50-50 basis, 50% to husband, 50% to wife. And finally, if you can't do it by agreement in a property settlement agreement, the court will do it for you in an equitable distribution hearing. So that's the information you may want to know as you begin thinking about what happens with your assets and your debts. If you're separating, you may want to speak with counsel in order to get a more detailed consultation on what that means. But that should at least get you started, get you thinking about the things you need to be thinking about when it comes time to divorcing your spouse. I hope that was helpful to everybody. If you have any questions, you can reach out on our website at probstlawfirm.com. You can call our number at 336-721-9090, or you can email me directly, bob@probstlawfirm.com. Thanks for listening, and as usual, we'll be back here next Wednesday at 4 o'clock. If you have a subject you would like me to talk about, reach out on my website, shoot me an email, or leave a message on this Facebook page, and I'll cover that area for you. Thanks, everybody. Have a nice Wednesday. Stay safe. Peace to everyone.